Sale of Goods Act of 1930. It is in the Block 2, Unit 1. It's a Block 2. It is also a special type of contract. The word or the act itself says that is sale. What sale with respect to goods. So what we have to study in this Sales of Goods Act, it's only that what are the goods that can be a subject matter of sale and how a sale can be done, and what are the rights and the duties or whatever the theories or what are the essentials of valid contract of sale. This is also a species of general contract act what we have studied in the unit 1st and 2nd. It is also a special type of contract because it contracts exclusively deals with some persons, so hence it is called as Sales of Goods Act. So what is a sale of good? Good, as you know, it is a commodity. So what sort of commodity? It's only movable goods we are talking about, because sale of immovable property or immovable goods, removable property deals in the Transfer of Property Act. So in the sale of goods we are only dealing with sale of movable property. And hence what is a sale of good? The definition clearly says it is also a contract. Contract means it is a basic principle of contract. Section 10 of the Contract Act must be required to make this Sale of Goods Act valid. So it is a contract of sale where contract means agreement. So it is necessary an agreement between the seller and the buyer for what? To transfer the property or agree to transfer the property. That means is the present transfer. If both the seller and the buyer ready and willing to take that property, it is selling or a transferring of property. Agrees to sell means it is in a future date. Selling and buying both are at a future date, that is called as agreement. So in where a sale where seller transfers or agree to transfer what? The property in the goods. That means property in the goods means not handed over the property, actual goods, but is a property in this act mentions as a proprietorship or the ownership. So even though sometimes possession is not hand over from the seller to the buyer, but property means ownership was said to be transferred. So in a sale of good, the seller transfers or agrees to transfer the property in the goods to the buyer for a price. Price is always money. So a contract of sale includes a sale or an agreement to sell. So two types of sale may be possible. One is sale and another means agreement to sell. So what is an essential element that must be necessary? Basic. Again we have to come into the basic structure of the Contract Act. That must be two parties, because one cannot buy his own product for himself or one cannot sell his own product to himself. So that must be at least two parties. One has to buyer, one to be a seller. So two parties must be there, or it may be a transfer, or it may be an agreement to transfer the ownership in goods. So say for example, I am owning a vehicle. I am a owner of a vehicle. So I want to sell my vehicle. That means I have to transfer my ownership right in the vehicle to the buyer. So that is nothing but transfer of ownership of goods. Possession of the goods may be taken at any time, but passing of ownership is very much essential in case of sale of goods. So it is a ownership that is to be transferred in case of sale, or it is agreed to be transferred, means proprietorship is going to be transferred at a future date in case of agreement to sell. So subject matter of sale is always movable good. Immovable property is not subject matter of sale, and hence similarly now services is included in sale of goods. So consideration always be for a price. Price means money. So if the goods are exchanged for goods, that is not sale of goods, but that is considered as a barter. Exchange of goods is said to be barter, but if partly goods and partly money is transferred, it is also a valid sale under the sale of goods. And lastly, all the essential element of a valid contract. That means competency. Both seller and the buyer must be competent to contract, consideration must be lawful, object must be lawful, and then free consent must be obtained in case of sale. Similarly, according to the definition, property in goods must be transferred from one person to one person. Hence, what is a good? What is meant by goods means any movable property. Any goods perceived by the senses is called as a good. So, any movable property other than the actionable claim and money. Money cannot be, because price consideration itself is money, and hence money cannot be considered as a goods and hence actionable claim. That means whatever the amount that is to be obtained at a future date, that can also not be a goods. And any goods, for example grass, crops, stocks, or a copyright, patent, trademark, and also whatever the property that can be severed from the earth, that is called as a good. So for example, a tree, a living tree cannot be a good as and unless it is severed from the earth. So any property which can be separated from the earth can be a subject matter of good. Then kinds of goods, it may be existing goods or may be future goods. Existing goods means any property which is in existence at the time of entering into a contract. Hence, future goods, the goods are to be obtained at a future date, that can also be a subject matter of good. Then contingent good. We all discuss the contingent contract. Contingent means happening or not happening of a particular event. Similarly, if the goods are not in the hands of a person while making a contract, so it is to be procured from somewhere, and after procuration a contract can be completed. In such cases, such goods is called as a contingent good. Then specific goods. Specific goods means goods which are identified and agreed upon at the time of contract, and they must be in a deliverable state. So specific goods must be identified means what sort of goods or what kind of goods and what quantity of goods that is needed to the buyer, that must be agreed at the time of making the contract of sale. Say for example, A is a wholesaler of selling rice. So in his godown, he kept lot of rice bags. Suppose if the buyer identifies some 10 bags of rice that is to be given to the buyer, in such cases that 10 bags is considered to be identified and that is agreed to buy that 10 bags of rice. That is called as specified goods, and if that all thing has been done to make it in a deliverable state, suppose rice is to be packed and must be sealed and must be weighed, if these are all the things is done, that is considered as that goods in a deliverable state. In such cases, if any good which has been identified and it's in a deliverable state, it is called as specific goods. And unascertained goods. Unascertained goods means which are not identified and agreed upon, but mere description. Similarly, in the last example, if it's a manufacturer of rice, he has kept so much of bags of rice in his godown. How much of rice and which bags the buyer is going to buy, that has not been specified. Only he has described that he wants to buy some 10 bags of rice. But what sort of bag, that has not been identified and agreed, that goods is called as unascertained goods. Suppose while making an agreement of contract of sale or after making of a contract of sale, if the subject matter, the property in goods is destroyed without the knowledge of the buyer or the seller, then such contract becomes void because no fault on either of the party, that subject matter is destructed, then the party cannot enter into a contract. Or else good perished after a contract of sale. So after making of the contract, if goods has been destructed or goods perished, in such cases, if it is a sale of goods of a specific goods, the contract is void. If it is uncertain goods, then contract is valid, because if the goods have been identified and that identified goods is destroyed or perished, that cannot be taken back. In such cases, contract is void. Suppose if it is uncertain goods, means any other 10 bags can also be, some other goods also can be taken. In such cases, the contract is not void, it is valid. Then how a contract of sale is formation is possible? Normally, when a contract is made by the seller and the buyer, either to sell or to buy, that means if the sale and the buy takes place simultaneously, then contract of sale is said to be completed. Or delivery in the later part, payment in the previously, that is also considered to be a sale of goods, or vice versa. Or delivery by installment, payment is also by installment, then also formation of contract is said to be completed. Only thing is, if both the parties have agreed to transfer their proprietorship in the goods, then contract of sale takes place. Then when a seller agrees or agree to sell the property in goods to the buyer, then he must deliver the goods. How he can deliver? By actual delivery. Actually giving possession of the property to the buyer, that actual delivery can be taken place. Or by symbolic delivery, because some object is such heavy or in such that one cannot hand over the property in goods. Say for example, in case of vehicle. So while a person seller is buying a car, by selling a car to the buyer, then he cannot hand over the possession. So what he will do? He will deliver the key symbolically, which shows that he is delivering or he is giving a possession. In such cases, delivery of the key or a delivery of a document symbolizes that property has been delivered. And constructive delivery. In case of constructive delivery, without affecting the change in the possession of the property, transfer takes place from one person to another person. For example, A is a position of goods for S. Say for example, A is having a godown. Some goods belonging to S was in the possession of A in his godown. So S transfers or A sells those goods to X. But the possession still or that goods still lying in that godown. So without disturbing the possession of the goods, transfer of property can be taken place. That is called as constructive delivery. These are all some of the examples with respect to sale and agreement to sell. Sale is always when sale is happened, ownership is said to be transferred. So and all the risk and also ownership is said to be transferred to the seller, buyer. But in case of agreement, that goods are still in the possession of the seller. So always risk lies with the seller and possession also lies with the seller, and its ownership will be agreed to transfer at a future date, and any risk or any damage is caused to the goods, always seller is liable. This is one of the foremost important aspect in case of sale of goods, because every person buying the property to satisfy himself for what purpose he is going to buy that goods. So say for example, a person purchase some milk. That milk must be of a consumer quality. If a milk is stale or it is contaminated, it obstructs or it destroys his health. So whatever the property or the goods which the person is going to buy must satisfy his needs. So always some conditions must be attached before selling the goods. So these conditions are always within the contract itself. Suppose if it is an express condition, the contract may be entered into by the parties by making an external agreement. But there are some conditions which are implied. That means not necessary to any act by the seller or the buyer, but the contract includes in itself some of the conditions and the warranties. Suppose if a person selling in any bread or any sweets in a bakery, condition as to that is it is of a consumable quality. So if any product in the bakery it is not of a consumable quality, then condition is said to be invalidated or it's said to be violated. So in all cases of sale of goods, this condition and warranty is very much important. So we have to see what is considered to be a condition. So the definition of condition is, it is a stipulation essential to the purpose of the contract, the breach of which makes the repudiate the contract and claim for damages. That means a right to treat the contract as repudiated. That means if any of the condition which is attached to a particular sale of good, in such cases any seller violates this condition, in such cases that sale is considered as a breach and the buyer can repudiate the contract. Similarly, warranty is nothing but it is also a stipulation collateral to the main purpose of the contract. Condition is that it is essential to the main purpose of the contract, but warranty is a stipulation collateral to the main purpose of the contract, the breach of which give rise the party to not to repudiate but to claim for damages. In case of violation of a condition, the party can cancel the contract and can also claim for damages. But in case of warranty, the party can only claim for damages and not for repudiate the contract. That means he cannot cancel the contract, he can only claim for damages. Say, just a best example can be given in that is because a lady ordered for a red sari to be wear in her marriage. So, color of the sari and the date of marriage is considered to be a condition, because if the sari has not been given within the date of marriage, so purchasing of sari becomes invalid. So purchasing of a red sari is a condition essential to the contract, and also delivery before marriage is also essential to the contract. But payment to the sari is a collateral, because payment can be made even after the marriage also. Suppose if the girl has not given the payment for the sari, that seller can ask for or he can file a suit against the buyer after the marriage also. But giving of the sari is very much essential before that date, and hence condition is very important. It is a collateral, is a warranty. So these both conditions of warranty, it may be either express or it may be provided in the agreement. Normally if it is can be express or it may be implied. So normally not necessary to we have discussed the express conditions, because the parties, whatever the condition that can be imposed by the agreement of the parties, only we are going to deal with the implied conditions. Implied condition, first implied condition as to title. Title means ownership. So one who is a owner can transfer a better title. If one person is having a title over the property, he can transfer that property to the owner, or else he cannot transfer a better title. Similarly, sale by description. Say, for example, if any property has been sold, by describing that property, that buyer has to or the seller has to give that property according to the description. So whatever the property has been described by the buyer, that property or the goods must be of the same character. It must correspond with the description. Say if the buyer asks to deliver the goods in package, in such cases, if the package is the description, the property must be delivered in the same condition. Suppose if it is sale by sample, if sample is shown by the seller, then whole goods must be correspond with the sample only, and at the same time the buyer always given an opportunity to examine the goods, and goods must not have a latent defect. Latent defect means that cannot be found out by an ordinary using ordinary knowledge. Then same sale of sample as well as by description. Same. If the property of the seller shows the goods and describes the goods, and the buyer makes known what kind of property or the goods he want to buy, in such cases it is sale by sample as well by description. For example, if the buyer wants to purchase sunflower oil, by showing the sample, the seller is going to sell the sunflower oil, but after or while making delivery, if that sunflower oil mixes with some other oil, then it breaks the condition as sample as well as description, then the buyer can repudiate the contract. There is one rule in a Sale of Goods Act, that is the doctrine of caveat emptor. Doctrine of caveat emptor means buyer must beware while purchasing the goods, because always burden is always on the buyer to purchase the goods for matching with his purpose or to satisfy his purpose. So if the buyer purchase himself a bad good or a dilapidated or a destroyed bad things, then he cannot blame the seller. In such cases, the rule is that always buyer must beware while buying the goods. But there are certain exceptions for this doctrine of caveat emptor. In such cases, buyer not liable for purchasing those goods. So what are those exceptions? Suppose if the goods have been sold, condition as to quality and fitness. Quality and fitness means for what purpose the buyer is going to sell, buying those goods which were made known to the seller. In such cases, the seller cannot sell other than those goods. Say for example, if the buyer wants to buy some goods and he specifies to the seller the purpose for which he is required. Say for example, if A goes to a bakery and order for a piece of cake. So why that not necessary that the buyer must explain for what purpose he is purchasing the cake. It is for consume. So in such cases, the cake must be of a consumable quality. If the buyer have or caught something, the same was one case with respect to one person purchased a bun for eating purpose. A stone was found in the bun and thereby his teeth was broken. So that means that bun was not of a consumable quality. So when that bun was not of a consumable quality, that is not fit for the quality and the fitness, and the buyer at all right to rescind the contract. Similarly, but in that case, two things must be satisfied. One thing is depends on the seller's skill. That means a person who wants to buy some special or any goods, he must go to a special person. Secondly, the seller must deal in those type of goods. We cannot go to a provision store and ask for milk. We will go to a dairy or a milk booth to ask for the milk. That means the seller is dealing with the same goods. Second condition as to mercantability. Mercantability means mercantile is a sale. So any goods which the buyer is going to buy, that must be fit for the purpose, and also it is of a resaleable value. So that is mercantability. If any condition violates as to mercantability, the buyer can reject the goods. So if any goods which is destroyed by some other external facts, then condition as to mercantability is said to be failed. Suppose if any grain was damaged by rain while loading or while packing, so it is of a not resaleable value. In such cases, it is a violation of condition as to mercantability. And thirdly, it is a condition as to usage implied by custom. In some cases, not necessary the buyer is going to purchase some of the goods for a particular purpose. Say for example, if the buyer wants to buy a umbrella, that the implied condition that it is for a rain or for a sun. In such cases, buyer need not necessary to explain for what purpose he is going to buy that. So it is condition as to usage or the custom. And fourthly, condition as to wholesomeness. Wholesomeness means it is of consumable quality. In case of consumable goods, whatever the goods the buyer is going to purchase, that must be of a consumable quality. Otherwise, it is a violation of a condition. Similarly, warranty. Warranty is not that much important because the person cannot repudiate the contract for the breach of warranty. So, first on the warranty is to undisturbed and quiet possession. Suppose if the buyer purchase any good, it may be a vehicle or it may be anything, he has entitled to have a quiet possession over the property. No one can be disturbed from his ownership. And secondly, it free from any encumbrances. That means no charges must not be there on any particular goods. It's free from encumbrances. Thirdly, any dangerous nature. If any buyer is going to purchase any goods, seller must explain if any dangerous nature of goods is there. Suppose if it is taking any juice bottle, or while opening the bottle, if gas comes out of the bottle and injures the eyes of a buyer, that is breach of warranty. In such cases, in any good, it is of a dangerous nature, that must be communicated to the buyer. And lastly, warranty as to quality and fitness by usage of a trade. In the same as the condition, and quality and the fitness must also be fulfilled in case of warranty. But only difference between the warranty and condition is, in case of violation of a condition, the contract can be cancelled and claim for damages. But in case of a breach of warranty, the buyer cannot repudiate the contract, only he can claim for damages. So once a contract of sale is completed, property in goods must be transferred. So when passing of property takes place, so the property in goods is said to be passed to the buyer when we acquires proprietary rights over them. Suppose if the buyer acquires ownership right over the property, then property of goods is said to be transferred, though possession is not transferred. Or transfer of property in goods or transfer of possession of goods. That means passing of property can be made either passing of the proprietorship or by passing of the possession of the goods or passing of the risk. Goods are in possession of somebody else, ownership is passed, along with the ownership, risk also passes to the buyer. In case of specific goods, passing of property is taken place only it is in a deliverable state. In case of a specified goods means it is identified and agreed. As long as the goods are specified or unless agreed, risk or the ownership does not pass to the buyer. In case of specific goods, not in a deliverable state. So, if something is to be done, say for example weighing, testing is to be done on a specified goods, in such cases it is considered to be not in a deliverable state. So, unless the specific goods, property in goods is transferred, once all these have been done and a buyer has notice of that the goods are of a deliverable state. And sale on approval also possible. Proprietary passing of proprietary right can also be made by sale on approval. Approval means giving consent that he has accepted the goods or he is ready to accept the goods. That is called a sale of approval. So, certain rules are laid down for passing of the property. So, some certain rules are, one is the delivered, that is the goods are delivered on approval or on sale or return. That means if a condition is put while taking the delivery of the goods or buying the goods, in such cases, once a goods is transferred, that is a completed sale. Or the buyer can take it for test, or if he does not want to buy, he has to return the goods. So, sale or a transfer of property can be taken place either by sale or by approval or by sale or return. So, in such cases, by acceptance, passing of property can be taken place. Suppose if the buyer signifies acceptance, suppose seller wants to sell, buyer accepted to buy. So, on acceptance or giving consent approval, he adopts the transaction, the sale is said to be completed, transfer of property is said to be passed. So, for example, A gives his horse to B on sale on approval. Suppose if the B consented, A will ready and he sell his horse to B. B agrees to keep the horse. B has consented or accepted to take the horse, then transfer of property is saying to takes place. Or sometimes A gives the goods to B on sale or return. That means if the buyer takes the goods in his hand, instead of returning it or instead of accepting it, he retains the goods with himself or he pledges the goods with somebody else. That means he himself has accepted. Without returning the goods, it deemed to be accepted the goods. Then if the buyer does not signify his approval but retain the goods, that means sometimes seller has not made any note. Either he has accepted or he has rejected but keeps the goods with himself, is deemed to be consent. In such cases, if the goods have been not returned within a reasonable time, it is considered to be sale on approval. Then sale of unascertained goods. So, sale of ascertained goods is made possible when goods are made specified and agreed upon and they are in a deliverable state. Similarly, in unascertained goods, sale of property of these goods can be made possible only when goods are ascertained. So, when the goods are in a godown, they are unascertained goods. So, it has been some package, some weighing has been made and made it as a specific goods, then property in goods can be transferred. And also sale of unascertained goods or future goods. So, yet to be manufactured or yet to be procured, those goods are called as a sale of goods at a future date. In such cases, that property passes to the buyer only when the goods of that description in a deliverable state and unconditionally appropriated to the contract. So, it is of unascertained goods, goods must be ascertained and it must be appropriated to the contract unconditionally. In such cases, that ascertained goods or future goods by description can be a subject matter of sale. And along with the transfer of goods, transfer of risk also passes. So the goods remain with the seller's risk until the property in goods is transferred to the buyer. Property means ownership. Without having a possession over the goods, if the proprietorship transfer from seller to the buyer, risk passes to the buyer, though the possession was with the seller.